today's video, we discuss whether COVID relaxed telemedicine laws. Hi, I'm Michael H. Cohen. I'm founding attorney of Cohen Healthcare Law Group. We help healthcare industry clients just like you navigate complex healthcare and FDA legal issues so you can launch or continue to scale your health and wellness product or service. Now, broadly speaking, a number of states did relax the requirement that physicians treating patients in their state be licensed in that state. So, for example, before COVID, Virginia's medical board required that the physician be licensed both in their home state and in the state where the patient is located, presumably, in this example, in Virginia. Now, during COVID, Virginia relaxed this requirement, but only if the physician would be engaged by a local hospital, licensed nursing facility, or a dialysis facility for the purposes of assisting that facility with public health and medical disaster response operations. So this was basically a very narrow, targeted exception to facilitate COVID care. Virginia also allowed treatment where the physician had a pre-existing relationship with the patient. So some nuances there. Remember, there are really two big threshold issues in telemedicine. First, does the medical doctor, psychologist, or other licensed healthcare provider need to be licensed in the patient's state? And second, even if licensed, do they have to provide a good faith initial exam? And under that second question, does that initial exam have to be in person, or can it be done by audio-visual means, aka digitally, aka over the internet, via laptop, tablet, mobile phone, or some other device? And what is required before that audio-visual encounter is sufficient. For example, many states require that the healthcare practitioner must have been able to ensure that the patient is who they say they are. So some identity verification. Now, there is a third hidden issue at play, and that's the standard of care. I say hidden because the healthcare provider always has to meet the standard of care, even if licensure issues are satisfied. But the law allows a digital-only first encounter. The first meeting is digital. And in at least one recent case in California, the medical doctor providing telemedicine ran into trouble because, the medical board said, he did not meet the standard of care when prescribing drugs for the patient's sexual dysfunction without first offering an in-person exam. In this disciplinary action, the patient presented with ED. The Medical Board of California, using 20/20 hindsight, said it would have expected the physician to take a detailed medical history, including urological, neurological, cardiorespiratory, and psychological elements, which should include determining the etiology of the ED and contraindications to the recommended medication. The board required not only taking vital signs, but also a genital examination and a detailed sexual and social history to screen out for various mental health issues and social issues and other aspects of the patient's condition. So, as you can see, the standard of care issue is hidden, but it can come back and bite the practitioner. Whether medical boards will extend this line of attack against telehealth companies remains to be seen, because after all, standard of care is an obligation by the practitioner. But there are always byways in the law, and if there's a line of attack available to the medical boards, it is possible that it could be available to private plaintiffs to try to exploit it as a predicate for some other theory of liability, such as, for example, unfair business competition. So if you're interested in a quick and but useful early read on your business model, book a legal strategy session with us. Lots of clients have found it very, very useful. Thanks for watching. If you still have questions, click on the link below, cohenhealthcarelaw.com/contact to book an appointment or send us a message. Here's to the success of your healthcare venture. We look forward to speaking with you soon.